House will come back to order. This House will come back to order. Mr. Clerk, you want to ring the bell? Clerk will read the caption to a group of privileged resolutions.
Commending and congratulating Kevin Morris on being selected as a Marshall Scholar, honoring the life and memory of Johnny B. Corbett, honoring the life and memory of Judy Cecilia Harris, and for other purposes, that completes the reading of the privileged resolutions.
Is there any objection to the adoption of the resolutions? The chair hears none, and the resolutions are adopted. We are going back to the rules calendar. Going back to the rules calendar. Clerk will read the caption to House Bill 543.
House Bill 543 by Representative Illustration in the 104th and others to be entitled an act to amend Article 1 of Chapter 7 of Title 19. The official go to Georgia annotated relating the general provisions regarding parent and child relationship generally, so as to provide for equitable caregivers. This bill having referred to the Committee on Judiciary. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Illustration to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I present to you House Bill 543. What this bill does is it allows judges to have greater discretion in making important child custody determinations. First of all, under the Constitution, a parent must first be found to be unfit. That's only the time when these considerations would be given. But then what it does is it broadens the law to allow a judge to consider things from really the child's perspective. In other law, we have a very rigorous family relationship structure, but this is who has filled the role similar to a parent for that child. I know the hour's late. Mr. Speaker, I'll be happy to answer any questions.
You have a couple of questions if you care to yield.
I'll take two, Mr. Speaker.
Chair recognizes Representative Rogers to your right for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes, sir.
Chairman Illustration, isn't it true that one of the main factors that this bill does is to give judges greater discretion and in making a determination about a loving home for children who have been deemed to have come from an unfit home?
I thank the governor's floor leader for that question. This is a very important bill that will allow for greater discretion for trial courts to make the right determination as to custody that's best for the child.
And it will only be done as the judge sees fit. He takes it all factors into consideration, and it's the last measure, but he just wants to find these children a loving home.
Yes, sir, exactly. Thank you for the question. Thank you.
You have no further questions.
I yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 543 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 543. The ayes are 142, the nays are 15. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 493.
House Bill 493 by Representative Tanner of the 9th to be entitled an act to amend Chapter 2, Title 8. The official go to George Ann Taylor relating the standards and requirements for construction, alteration, etc. of buildings and other structures so as to provide procedures for alternative plan review. This bill having referred to the Committee on Regulated Industries. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Tanner to present the bill.
Thank you, Mr. Speaker. House Bill 493 is a bill that's been worked on for a couple of years now between ACCG, GMA, the Engineering Association, and also the contractors. This is an agreement that they've been working on to streamline the review process, to shorten the time frame that the local governments have to review that from 30 business days to 30 days, or 6 weeks to 4 weeks. It also allows owners to go directly to the private sector for review if they're willing to only pay, or if they're willing to continue to pay the full fee at the county or city level. It also requires any private plan reviewer's insurance to go to double. The liability insurance will double. And it also allows, Chairman Barr had worked on a bill dealing with soil and sediment control planning, again supported by ACC and GMA, and it will allow for private reviews of that if the county does not have their issuing authority. Now you have to go directly to EPD. This would allow for a private engineer to do that review. County and cities can set up preferred or required engineers to do that if they choose to. If the county cannot perform within the time frame outlined, then the person could move forward with a private inspector, but they would only have to pay 50% of the regulatory fee. If they chose to do it earlier, then they'd have to pay 100% of the fee. Mr. Speaker, I know the hour's late. Again, this is something that's been worked on for a couple of years, ACC, GMA, and the industry, and I'll be glad to answer any questions.
Chair recognizes Representative Henson to your left for a question.
Thank you. Will the gentleman yield?
I will.
I have some concern with how this is going to affect our soil and water conservation, district conservation folks, because it's saying you can hire a private professional provider to inspect for erosion and sediment control plan.
Yes, ma'am. This is in cases where the county or city does not have the issuing authority. So City of Atlanta, the county I live in, they have issuing authority, so the county would do that. But in cases where they do not have that issuing authority granted by EPD, then they could then use the private company to do that. And it outlines that that private company cannot have been involved in doing the plan. They cannot have worked for this company before, etc. So there are some safeguards. And again, the cities and counties have been involved in this process, and that part of the bill they strongly support. And also, I think Chairman Welch has worked along with Chairman Barr very closely on this part of the bill.
Further question?
Yes, ma'am.
I know that some of our cities in DeKalb aren't issuing authorities, but I believe that they work with the county on it. How will that affect the situations in DeKalb County?
So if I understand your question, I want to verify this. You're saying that the city does not individually do it, but they have a intergovernmental contract with the county to provide issuing authority. Is that correct?
I believe so.
In that case, again, this would be my understanding. I want to clarify, not 100% certain, but it would be my understanding then the county would continue to do that. This is only in cases where the county or city has no issuing authority and they have no one providing that service, and the person's having to go directly to the state, directly to the EPD. This will be beneficial for the county because they won't have to wait that extra length of time waiting on the state to do the process.
Thank you.
Thank you very much. Mr. Speaker, with that, I'll go ahead and yield the well and ask for favorable consideration of House Bill 493.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 493 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 493. The ayes are 142, the nays are 20. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 339.
House Bill 339 by Representative McLean of the 100th and others to be entitled an act to amend Code Section 4286 of the Official Code of Georgia Annotated relating special license plates promoting and supporting certain beneficial projects, agencies, funds, or nonprofit corporations, so as to establish a specialty license plate to benefit Alabama A&M University. This bill having been referred to the Committee on Motor Vehicles. That committee recommends that this bill do pass.
Chair recognizes Representative McLean to present the bill.
Thank you, Mr. Speaker. Colleagues of the House, I bring you HB 339 for your favorable consideration. This bill will allow the proceeds from the sale of this tag to provide scholarship funds for only Georgia students to attend Alabama A&M University, where Georgia students make up the second highest number of students that attend that college. Thank you, Mr. Speaker, and I will definitely yield for all the questions I can have.
You know, when you say that, they light up, Representative. Chair recognizes Representative Al Williams to your left for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes.
Will you tell us about the bottle of water? I know this is a heavy bill and you were expecting to be up there a long time, but tell us about the water.
Well, Representative Williams, I've been waiting 6 years for this opportunity, and I feel like that I do need at least one bottle of water for this opportunity. Mr. Speaker, I still yield for other questions if there are.
You want more questions over this bill?
Yes, I would like to, if I could.
Okay. Chair recognizes Representative Walensky to your right for a question.
Thank you, Speaker. Do you yield?
Yes, I do.
I see on line 16 there's a phrase, "Go Bulldogs." I only know one team here in Georgia that we use the phrase "Go Bulldogs" for, sir.
Yes, there are, but there are roughly about 21 high schools that have the name Bulldog.
Thank you, sir.
Thank you. Mr. Speaker, I yield well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 339 will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 339. The ayes are 156, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 315.
House Bill 315 by Representative Newton and the 123rd and others to be entitled an act to amend Article 1 of Chapter 80 of Title 36, the official code of Georgia Annotated, relating to the general provisions applicable to counties, municipal corporations, and other governmental entities, so as to provide for certain agreements from consultants who enter into contracts or arrangements with counties, municipalities, or other local entities to prepare or develop specifications. This bill has been referred to the Committee on Governmental Affairs. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Newton to present the bill.
Thank you, Mr. Speaker. Colleagues, I know the hour is late. Very briefly, House Bill 315 addresses an important taxpayer appropriation type question. We have great appropriations leadership here. The colleagues work together. We appropriate about $27 billion in state tax funds a year. Another $11 billion, however, is appropriated through local property taxes and projects of various sizes in our local cities, counties, and authorities. House Bill 315 will help improve transparency when these local governments spend taxpayer money, in particular on fairly large, high-dollar projects. This bill provides that when local government projects that do two things, they reach a threshold that requires an RFP or a particular bid package to be done, and number two, the county doesn't have the in-house capability to prepare a bid package or an RFP themselves. They need someone else to help with that RFP, the scoring process, specifications. If they have to hire an outside consultant, House Bill 315 requires disclosure of any material, financial relationships that the consultant advising the county would have with one of the bidders that is bidding to do the work. This would help prevent conflicts of interest, but in particular, it would give transparency so that the cities and counties could know exactly where the financial relationships might be between certain bidders. And in smaller communities, there may very well be some financial relationships or past work that they've done together. So this doesn't prohibit them from working on it or being a consultant. This just requires disclosure of any material transactions like that or financial relationships. This bill passed in a little different position, passed nearly unanimously in the House and Senate last year, but was vetoed due to by the governor due to abundance of caution. There was a concern that the current exclusion from open records acts right now that's provided for economic development activities might be hindered by this requirement to disclose. So what we did in this bill is we went back and we excluded economic development activities, both at development authorities locally and also the larger state economic development activities in the code sections in there. I think this new bill corrects those, and I know this is an important issue. When that type of money is spent, when taxpayer money is spent, there is a very high bar that the taxpayers can be confident that the people recommending how the money is spent, the people doing the work, that the taxpayers can get the best job for the best price for their hard-earned tax dollar. Appreciate your support of House Bill 315, Mr. Speaker. I'm glad to answer any questions.
You have no questions.
Thank you. I yield the will. Appreciate your support.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 315 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 315. The ayes are 161, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 349.
House Bill 349 by Representative Martin of the 49th being entitled an act to amend Code Section 3644.3, the official code of Georgia and Tennessee relating the definitions regarding redevelopment powers. This bill having referred to the Committee on Government Affairs. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Martin to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, this bill is a permissive bill, and it helps our smaller cities take advantage of redevelopment powers. What it simply does is allow a county or a redevelopment agency to operate within the corporate limits of a city on a project if that project is approved by resolution of the municipality, and that is on a project-by-project basis. So it is completely permissive. We have a situation up in northwest Georgia where the city of Emerson wishes to participate in a project. They don't have redevelopment powers. They don't want to pledge their increment. They don't have to do any of that. They can approve it by resolution, and the county redevelopment authority can bring jobs and opportunity to that portion. Mr. Speaker, if there are no questions, I would ask for favorable consideration of House Bill 349 to bring jobs to northwest Georgia.
You have no questions.
Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 349 will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 349, the ayes are 165, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 553.
House Bill 553 by Representative Dempsey of the 13th and others to be entitled an act to amend Code Sections 3562 and 49.5.281 of the Official Code of Georgia Annotated relating to the membership of the State Victim Services Commission and the Bill of Rights for foster parents. This bill having been referred to the Committee on Code Revision, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Dempsey to present the bill.
Thank you, Mr. Speaker. I bring to you tonight a measure that deals with code sections. It started off as one thing, so that's what you will see on the front of it, dealing with the State Victim Services Commission to remove some outdated information. There's one agency listed that does not exist anymore. But then some things were added thanks to Chairman Barr and Welch and Harrell and others who did a great job of making sure we tidy up the codes. It's very important, I think, for those codes to be exactly right. So this involves inactive, dissolved, and not funded boards and authorities. This will clean them up. I know the hour is late, Mr. Speaker, and I know we're trying to get a lot of things done. So in the essence of time, I will yield the well and ask for everyone's favorable support.
Lady has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 553 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 553, the ayes are 162, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 514.
House Bill 514 by Representative Tanner of the 9th to be entitled an act to amend Chapter 1 of Title 37 of the Official Code of Georgia Annotated relating to the governing and regulation of mental health so as to create the Georgia Mental Health Reform and Innovation Commission. This bill having been referred to the Committee on Health and Human Services. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Tanner to present the bill.
Thank you, Mr. Speaker. House Bill 514 creates the the Behavioral Health and Reform Commission. This will be appointed by the Speaker, the Lieutenant Governor, the Governor, and the Supreme Court, and it will go until June of 2023. Mr. Speaker, with that, I'll yield the well and ask for favorable consideration for House Bill 514.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 514, the ayes are 152, the nays are 10. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 540.
House Bill 540 by Representative Rhodes, the 120th, and others to be entitled an act to amend Code Section 33-118. The official code of Georgia annotated relating to housing tax credit for qualified projects and rules and regulations. This bill having been referred to the Committee on Ways and Means. The committee recommends that this bill do pass.
Chair recognizes Chairman Rhodes to present the bill.
Thank you, Mr. Speaker. I bring before you House Bill 540. It brings the Georgia Low-Income Tax Housing Credit in line with the majority of state LIHTC laws by including the insurance retaliatory tax among the credits against the premium tax. House Bill 540 will increase the amount of capital available for low-income housing projects in Georgia by opening up the usage of the credit to insurance companies subject to the retaliatory tax. House Bill 540 will have no fiscal impacts. Credits are capped annually based on the federal allocation. Mr. Speaker, the night is getting long. I ask for your favorable consideration. I yield the well.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 540. The ayes are 149, the nays are 10. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 483.
House Bill 483 by Representative Stevens, the 164th, and others to be entitled an act to amend Chapter 13 to Title 16. The official code of Georgia annotated relating to controlled substances so as to change certain provisions relating to Schedules 1, 4, and 5, controlled substances. This bill having been referred to the Committee on Judiciary, Non-Civil. That committee recommends that this bill do pass.
Chair recognizes Chairman Stevens to present the bill.
Thank you, Mr. Speaker. This is the annual drug update bill that we do in the House every year, the drugs that are released from the FDA. If you'll notice on your last sheet, some of the drugs have gone over the counter: epinephrine inhalers, Zysol antihistamines, which we all need with all this stuff here, sodium chloride, and triamcinolone nasal spray. Mr. Speaker, this is the same bill that we do every year that updates our code, and due to the late hour, I'll yield the well.
You have no questions? Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 483 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 483. The ayes are 161, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 551.
House Bill 551 by Representative Hill III to be titled an act to amend Chapter 13 and Title 16 of the official code of Georgia annotated relating to controlled substances so as to provide for legislative findings, to provide a definition, and then to provide for the identification. This bill having referred to the Committee on Judiciary Non-Civil, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Hill to present the bill.
Thank you, Mr. Speaker. I'd like to thank Representative Vernon Jones and Michael Caldwell after a long 9 months of study on this committee, and what we came up with is to protect our kids on the Kratom bill. Those that are 18 years of age or older have to be able to buy it, or where they can buy it. Provide for the packaging to be labeled, and so that we know what the what's in the packages, and to protect our consumer. And again, I would appreciate your favorable consideration on this. I yield the will.
You have no questions. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. All members voted? If so, the clerk will lock the machines on the passage of House Bill 551. The ayes are 164, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 530.
House Bill 530 by Representative Hitchens, the 161st, to be entitled an act to amend Article 16 in Chapter 2 of Title 20, the official code of Georgia annotated relating to students in elementary and secondary education, so as to prohibit parents or guardians from withdrawing or removing a child from a public school for the purposes of avoiding compliance with laws relating to mandatory attendance. This bill having referred to the Committee on Juvenile Justice. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Hitchens to present the bill.
Thank you very much, Mr. Speaker. This is a bill that we've been working on now for about 2 months. Anybody read the Atlanta Journal-Constitution yesterday? It was a front page article about abuse and neglect of some children that they found buried in the backyard in my home county. What this bill does is to try and protect the rights of homeschoolers, those people who actually withdraw their children from a school to homeschool them, and they file the proper documentation within 30 days, as opposed to those who, under the guise of homeschooling them verbally, take them out and then they don't, they get no response, or the school gets no response back from the Department of Education within 45 days that they're engaged in homeschooling or in another school. It requires the DFACS will do an assessment, and I'd like to say that we met until about 6 o'clock last night with the homeschooling attorneys, DFACS, and finally after 2 months everybody's on board with this. I ask for your favorable consideration, and I'll yield if we have any questions, Mr. Speaker.
You have no questions.
I
No,
yield.
you do have a question. I'm sorry. Do you yield?
Yes, sir, I yield.
Chair recognizes Representative Mary Frances Williams to your right for a question.
Do you yield?
I yield.
I've had a couple calls from homeschooling families in my district who are really worried that this is going to make it more difficult for them to homeschool their children without interference from public schools.
This has no effect. We've rewritten this bill now 7 or 8 times, and finally last night everybody came together and everybody's on board and in agreement. If there's an assessment made and they have made their declaration and they have a copy of it, DFACS will immediately leave the premises and stop the assessment.
All right. Thank you very much.
Sure.
No further questions.
I yield the will.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 530, the ayes are 135, the nays are 28. This bill, having received the requisite constitutional majority, is therefore passed. Okay, the chair, before we get deeper into the evening, wants to remind the members that we are operating on all bills with time limit on debate of 1 hour. That will be allocated equally between each side of the issue. That does not include the presentation by the author, nor does it include any minority report or the chairman's time, which are limited to 20 minutes each by rule. Chair also wants to remind the members that at the stroke of midnight, we are out of here. So, if not before. Clerk will read the caption to House Bill 426.
House Bill 426 by Representative Illustration and the 104th and others being entitled an Act to amend Article 1 of Chapter 10 of Title 17 of the Official Code of Georgia annotated relating the procedure for sentencing and imposition of sentence so as to revise the criteria for imposition of punishment for crimes involving bias or prejudice. This bill having been referred to the Committee on Judiciary and Non-Civil. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Illustration to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, this evening I bring to you House Bill 426, establishing hate crime statute in the state of Georgia. Now, on March 16th, 2000, this body was considering a very similar measure, a hate crime statute. And you've seen a speech that I had distributed out to your desks. At the time that evening, it looked like the bill was headed to be tabled. And a representative who was a Republican, Dan Ponder, who's with us this evening with his wife in the gallery, took this well and delivered a speech that ultimately led to the passage of that legislation. Now, what you might not know is 4 years after that bill was enacted, the hate crime statute was determined to be constitutionally unconstitutional because it was vague. And what that ultimately resulted in is an opinion in State versus Botts that held that Georgia's hate crime statute was unconstitutional. Now, there is a need in Georgia for a hate crime statute. And I could give many examples, but let me summarize. In 2017, the Douglas County District Attorney, a Republican, talked about how he desired to charge a criminal offense as a hate crime. That's where 15 individuals were taunting African Americans who were in a park at a child's birthday party. And as a result of that interaction, a man pointed a shotgun at the party and yelled racial epithets. And the Republican district attorney of Douglas County had to pursue prosecution under the gang statute because there was no hate crime statute at the time. This year, graffiti of swastikas were found on the campus of Centennial High School. This caused fear and disruption throughout the community. The message sent was not just the vandalism, but it was to others who would see that hateful message. In 2018, Gwinnett County law enforcement noted the increase in brutal attacks and armed robberies targeted at immigrants. And that's because of hate and a belief that the immigrants wouldn't call for help or pursue action in court. And specifically in December of 2018, 3 defendants are alleged to have perpetrated a brutal attack on Hispanic victims in Gwinnett County, leading to incredibly serious injuries in one attack and a death of a resident of the district that I represent, House District 104. Now, I know that the hour is late tonight, but I want to implore you that throughout history, we've seen how hate can be used as a powerful tool. It can be used to gain power for a select few. It can be used to intimidate and harass a specific group. And it can be used to undermine a government premised on equality and the rights of the people to live in freedom. This is not a Republican or a Democrat issue. As you see, there is bipartisan support, 3 Democrats and 3 Republicans that have signed this bill. I'm a Republican, and I'm convinced that government that governs in a limited manner governs best. But that most fundamental role of government is in our society to protect the most vulnerable. And that's what this bill seeks to do when individuals are motivated by hate to attack and harm their fellow citizens. Now, I submit to you that if you honestly search your heart and you conclude that someone may be more vulnerable to a crime because of being in one of the protected classes where this person could be targeted for an attack, then this bill is needed in Georgia. If you honestly search your heart and conclude that hate can be used as a tool for evil in order to undermine the law and order that we take for granted many times in our society, then this bill is absolutely needed. If you honestly search your heart and you conclude that you want your children and your grandchildren to grow in a society where overt acts of hate are not tolerated, then this bill is needed. Now, prosecuting attorneys, law enforcement, they appreciate the critical need for this legislation. And I'll end by quoting from the speech that's on your desk that was said in this chamber at the end 19 years ago. I believe that we must send a message to people that are filled with hate in this world that Georgia has no room for hatred within its borders. It's a message that we can send to the people of this state, but it's also a message that you have to send to yourself. I ask you to look within yourself and do what you think is right. I ask you to vote yes on this bill and vote no to hate. Mr. Speaker, I'd be happy to take any questions.
Do you yield for a question?
Yes, sir.
Chair recognizes Chairman Stevens to your left for a question.
Does the gentleman yield?
Yes, sir.
Isn't it true that Georgia is only one of 5 states in this country without a hate crime law?
Yes, sir, that's correct.
Isn't it true that I got a call this afternoon from my DA in Savannah that's asking for us to pass this bill?
Yes, sir, that's right. District attorneys across the state are asking for this legislation. Thank you. Mr. Speaker, I know the hour's late. I'll yield at this time, and if necessary, I know chairman time is available. Thank you.
You had, okay. Chair, we have other members that wish to be heard on the bill. Chair recognizes Representative Gilligan to speak to the bill.
Thank you, Mr. Gilligan. Mr. Speaker. Love you back there, man. You're on my mind. Thank you, Mr. Speaker. Today I do rise to speak in opposition to House Bill 426. Hate crime laws are written to punish prejudice and bias wherever it is found, but they are not enforced the way they are written. Hate crime activists say we need special laws to prosecute the crimes they choose to call hate crimes because, according to the activist, hate crimes are different from other crimes. Hate crimes are worse than other crimes. Hate crimes spread more fear than other crimes, and not prosecuting hate crimes represents injustice that harkens back to historical injustice against minorities, but none of these claims are true. Every year, hate crime activists enhance their numbers by using suspect data collection methodology. For example, in 2016, Of the 4,720 purported hate crimes against persons, nearly one half of those, 47.7%, of those serious hate crimes against persons were cases of simple intimidation. Essentially, they were name calling. Another 35.7% were simple assault, something as minor as shoving or touching. Since 1997, when Bill Clinton, Eric Holder, and Clinton's legal advisor, Elena Kagan, led the fight to empower these unelected activists to decide what is and is not hate, the biggest stumbling block for them and the entire hate crimes industry has always been women. The internal memos and congressional debate about hate crime and the hate crime laws in the 1990s were obsessed with finding ways to keep women from being counted as victims of hate. Because if you counted women, the approximate 10,000 stranger rapes and stranger rape murders per year would comprise the largest body of hate crimes. And stranger rape is a hate crime by its very definition, because it involves selecting a victim based on their gender characteristics and attacking that victim's sexual identity. But according to the hate crimes activists, stranger rape only counts as hate if the rapist demonstrates an additional animus against transvestites, gays, and lesbians, or in a tiny number of the thousands of interracial rapes that occur each and every year. And other rape victims just don't count. In 2008, Meredith Emerson was kidnapped. She was held hostage. She was tortured and murdered in the North Georgia mountains by a man who told the GBI he wanted to kidnap, torture, and murder a woman. He told the GBI that he chose Meredith because she was a woman. GBI Director Vernon Keenan never called this a hate crime. And the hate crime activists have been quietly working for 2 decades now to make sure that the thousands of Meredith Emersons will never be counted as victims of hate, because that would distract from their desired statistical outcomes. The solution the hate crimes industry found for the problem of too many potential female victims of biased crime is an ugly one. Behind closed doors, activists quietly trained police and prosecutors to not seek hate crime charges when the victims were merely women attacked for being women. Even in serial cases, even in cases involving sexual torture and murder, even in cases where women's genitals were mutilated and slurs carved into their bodies, and the point person for finding legal strategies to justify such exclusions is Elena Kagan, who sits on the U.S. Supreme Court. Such deceptive practices are the status quo throughout the hate crimes industry. The prejudicial consequences of these systematic deceptions are visible in the exclusion of entire victim groups from protection by these laws. Such targeted exclusions even extend to different victims of the same offender. In the year 2000, serial rapist Mark Anthony Lewis was charged with 8 counts of hate crimes in Chicago after being identified as the assailant in 9 rapes. So he was charged with hate crime for his rapes of 7 Asian women and his 1 Hispanic woman, but his rape of a white woman was counted as a lesser crime. Consider the murder of Tracy Thompson in Cordele, Georgia. Georgia law enforcement announced that they were trying to figure out if Thompson was killed because she was a transvestite, which would rise to the level of hate, or if her killer was just killing a woman. There are literally millions of examples of such dehumanizing applications of the hate crime law. Hate crime laws have returned us to the bad old days when some victims matter more than others because of the color of their skin or some other identity marker. Hate crime laws destroy 50 years of striving for true equality before the law. Hate crime laws have corrupted our justice system. They are drafted with the appearance of impartiality, but they are enforced everywhere with extreme bias. Hate crime laws submit criminal justice to politics. If hate crime laws were applied in good faith, the statistics would look something like this. The worst single hate crime would be 9/11, when almost 3,000 Americans were killed in anti-American nationality bias crime. Other instances of anti-American nationality terrorist murder would just add to that number. The most common serious violent hate crime would be serial stranger rapes of women and also men. There are, like I said, 10,000 of those every year. If we counted all slurs and prejudicial language present in the commission of other crimes as hate, instead of singling out only a few of them, then there would be countless cases of simple assault and aggravated assault hate crime committed every day, many, if not most of those, against women. There is zero evidence that any victim of a crime has been denied justice because we do not have hate crime laws here in Georgia. And finally, I say that we are lucky here in Georgia that we have not written such injustice into our laws. We are lucky that in Georgia, all crime victims are equal before the eyes of the law, regardless of their skin color or the skin color of their assailant. There is really only one way to keep our laws colorblind and dedicated to equality for everyone. Please oppose this bill. And Mr. Speaker, I yield the will.
Chair recognizes Chairman Welch to speak to the bill.
Thank you, Mr. Speaker. I rise in support of HB 426. And I've grappled with this issue for 2 sessions now because it's come before the judiciary and now the non-civil judiciary. And I think the concern that many have is, will this be used in an appropriate manner, or will it be used in a harmful manner? And I don't know the answer to that question, but I do know this, that when I think back to why I named my son Caleb Johannes Welch, I named him Johannes because that was the name of my great-grandfather who was a tugboat captain in Denmark, in Copenhagen. And he, during World War II, smuggled Jews from Copenhagen to Sweden. And when I think of this bill, I think of him, and I think of those innocent souls that he saved and those that he did not. And I think he would want me to vote for this. And I think my son would want me to vote for this. With that, I yield the will.
Chair recognizes the Dean of the House, Dean Smyrie, to speak to the bill.
Mr. Speaker and ladies and gentlemen of the House, I rise to support the House Bill 426, the hate crime bill. Before I go into my explanation, I just want to say publicly that Representative Administration, I have enjoyed working with you. When we talked back in December, Mr. Representative, we talked about this bill and the history of it. And I reflected back in 2018, and Representative Karen Bennett had a bill, and we worked and tried to perfect it, and Representative Megan Hansen had a bill, and we were both working together trying to come to some conclusion as to how we could get this bill passed. At that time, Wendell Willard was chair of the Judiciary Committee, and I can't remember being in Judiciary but one other time in my career in this House. But I went to the Judiciary Committee, and we were able to get a compromise out, and we met hours on hours, Representative Chairman Willard and I and others. And fast forward, here we are today. Chairman Administration has done an outstanding job of getting us to this point, and I just think about this: 45 states. 45 states have hate crime statutes. Georgia, Indiana, South Carolina, Wyoming, and Utah. Yesterday, Utah passed it in the Senate. Now it's in the Utah House. So I come and ask you very, very strongly to pass House Bill 26. 19 years ago, Dan Ponder stood in this well. And I'll never forget that day as long as I serve in this House. In fact, those of you all who have been here maybe 25, 30 years ago remember Papa Dent. Anybody remember Papa Dent? Dan Ponder's speech, in my opinion, in Papa Dent's speech, Papa Dent spoke on the poverty of our state and how we should have opportunities for people who are poor to pull them up by the bootstraps, and so that they could have a better quality of life. Dan Ponder's speech was on that same level of intensity and emotion in this House. I remember, and I'm so glad to see him here today, because he stated that, I agree when he said that hate has no discrimination when it picks its victims. And I just would hope we would do the right thing. House Bill 426 protects all of us in our communities and sends a message that we will stand together even amongst our differences. This has nothing to do with what I hear about religious freedoms, and I just feel very, very strongly that we're at this juncture that we want to move Georgia forward, and I think the right thing for us to do is to pass House Bill 26, and I would hope that you would vote in favor of House Bill 426, and everybody will have a fair share and a fair stake in our state. No one, and I mean no one, has the right to commit a hate crime and walk away to talk about it. No one ought to have that right. So, Mr. Speaker, I'd ask that you vote for House Bill, members vote for House Bill 426, and I yield the well.
Gentleman has yielded the well. For what purpose does Representative Beasley Teague rise?
I had a question, Mr. Speaker. Parliamentary inquiry.
State your inquiry.
Is it not true for the last 25 years I've been taking young children on buses to Selma so they can learn about the history of some of the civil rights activities before we got the voting rights bill? And then further, Mr. Speaker, parliamentary inquiry.
State your inquiry.
Is it not true that history will repeat itself if you don't know it? So that's why I feel like it's important for all those children, 2 busloads this time, to learn, because unless we do something to identify and help people in this situation, Mr. Speaker, it's just so important that we understand that the present laws on the books will not help people. Hate is in their heart, and I know the only thing can move that is love. But in this situation, we need some laws to be able to teach them how to love. Thank you, Mr. Speaker.
What purpose does Representative Stover rise?
To make a motion.
State your motion.
I move to table HB 426.
Gentleman has moved that HB 426 be tabled. Is there objection? There are lots of objection. All those in favor of the motion to table will vote green. Those opposed to the motion to table will vote red. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the gentleman's motion to table. The ayes are 47, the nays are 115. The motion has failed. Is there any objection to the previous question being ordered on House Bill 426? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machine. What purpose does Representative Stover rise?
Procedural inquiry.
State your inquiry.
I'd like to remind everyone of Rule 135.
I'm sorry?
I would like to remind everyone of Rule 135. Vote your own machine.
What purpose does Representative Gertler rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that we should not be raising or lowering the standard of one life over another just because there's irrelevant factors, what an individual looks like, or their gender, or who they love or worship, what political ideas they have?
I think that addresses itself to the determination of each and every member. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 426. The ayes are 96. The ayes are 96. The nays are 64. This bill having received Requisite constitutional majority is therefore passed. What purpose does Chairman Taylor rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that Dan Ponder is from South Georgia and represents many of us, and he is still sharing his wisdom in the newspaper? Thank you, Mr. Speaker.
If the lady so states, I will agree that I know that to be true. What purpose does Representative Vernon Jones rise?
Mr. Speaker, is it not true that I had the opportunity and the honor and the privilege
Is
to
this
serve?
a parliamentary inquiry?
Parliamentary inquiry, Mr.
State your
Speaker.
inquiry.
Is it not true that I had the honor and privilege of serving with Representative Dan Ponder in this body?
If the gentleman so states, I know that probably to be true. What purpose does Chairman Houston rise?
Is it not true that I can beat him? I had the honor to sit next to him when he made the speech. Thank you.
I think everybody's wanting to claim him here tonight. So, what purpose does Representative Dukes rise?
Parliamentary inquiry,
State your
Mr. Speaker.
inquiry.
Is it not true that while everybody is claiming the former Representative Ponder, but it is Representative Ponder who is my constituent? Thank you, Mr. Speaker.
I'll let you and Chairman Taylor debate that maybe. What purpose does Representative Al Williams rise?
Parliamentary inquiry, Mr.
State your
Speaker.
inquiry.
Mr. Speaker, is it not true that I did not have the privilege to serve with Representative Ponder, but I did have the privilege to watch him be named a recipient in profiles of courage, and I'm proud to know I live in a state that has a Dan Ponder.
So noted. What purpose does Representative Bennett rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that I am so overjoyed that this House has just passed this House Bill 426?
If the lady so states. What purpose does Chairman Welch rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that I'm honored to serve with Representative and Chairman Chuck F. Stration?
I'm sure that as well you should be. All right, this House will come back to order. Clerk will read the caption to House Bill 481.
House Bill 481 by Representative Setzler, the 35th, and others, to be entitled an act to amend Chapter 2 of Title 1 of the Official Code of Georgia Annotated relating to persons and their rights, to amend Article 5 of Chapter 12 of Title 16 of the Official Code of Georgia Annotated relating to abortion, to amend Chapter 9A of Title 13 of the Official Code of Georgia Annotated relating to the Woman's Right to Know Act, and to amend Chapter 9B of Title 31 of the Official Code of Georgia Annotated relating to physicians' obligations in the performance of abortions. This bill having been referred to the Committee on Health and Human Services, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Setzler to present the bill.
Mr. Speaker, ladies and gentlemen of the House, it is with deep humility that I rise today. I'd like to thank members of the House Health and Human Services Committee that when this bill was filed 10 days ago on the 25th of February, members began to read through the bill and prepare for a committee hearing yesterday that lasted for nearly 3 hours and was substantive, detailed, courteous. Both those for the proposition and against the proposition had every right to be heard. There were more than 10 amendments offered, and I appreciate Chair Lady Sheridan Cooper for the dignity and the opportunity for people on both sides of this question to be heard in full committee. These are not questions that need to be addressed hastily, and they've decidedly not been. As we consider this issue before us today in House Bill 481, I want us to all think about the things we do here and the people we serve. This is an extraordinarily diverse state. And in a day of political divisions, I come before you today speaking to people of both parties. I come today speaking to people of all backgrounds, of all ages, of all income levels, of all geographies, because this bill before us today and the question we'll be talking about in House Bill 481 goes right to the heart of humanity itself. We do lots of things down here that serve our communities. We do lots of things down here that serve our state well. But ladies and gentlemen in the House, there are a few opportunities we have, and there are a few. But this is an opportunity for us to debate and talk about the very meaning of human life and those that are worthy of our state's protection. Our job as lawmakers is to protect those who cannot protect themselves. Our job as lawmakers are to provide for those in difficult circumstances that need, in some cases, provision, a hand up to help them in their mean circumstances. And in other cases, provide opportunities and incentives for young people to achieve educationally and to live lives of fullness and goodness that our Creator intended for us. As I bring before you today House Bill 481, the issue before this House is the question of when should human life be protected by the law. There's broad consensus that the fragile children among us that are in neonatal intensive care units are worthy not only of our protection by law, but of our resources. Our insurance policies cover these kids' health care. Our laws and our Medicaid programs cover these children and care for these precious children, even if the parents live under the poverty line. We care for these children because the value of the human life is priceless. That's not something we peddle on. It's not something we trade on. And it's not something we even debate. Friends, we are a pro-life country. When there are miners trapped a mile deep in a coal mine, we spare no expense to save the 5 or 6 people for whom oxygen is expiring, to recover them from a coal mine and bring them back safely home. There is no expense we spare to protect the value of a human life. In fact, if we go to our neonatal intensive care units, there's no way economically we can justify the resources we spend to save these precious, tiny babies. But we don't justify it economically, we justify it for its humanity. We justify it for its humanity because we are good. Alexis de Tocqueville said in 1830, he said, "America is great because America is good. We're a light and a beacon to the world, and we as a state of Georgia are a trendsetter and a leader in what it means to be good." We feel the goodness amongst us as members of this body, the relationships we have across the aisle, across geographies, across age ranges, is a beautiful thing that those who are watching perhaps can never fully understand until you've had the honor to serve in this body and serve alongside the great public servants we have here. I am honored to serve with you. And I'm humbled deeply to be able to present this, Mr. Speaker, before the House. This is motivated by people who struggle. I've got in the balcony Miss Heather Hobbs. Miss Hobbs, if you'd stand up. Miss Hobbs is in the back. She was a military wife. She's with us tonight. She actually lives out of state. She's here today. And conceived her first child after having been brutally raped. She came today because she recognizes that even in that circumstance, that horrible circumstance that befell her, and the circumstances by which this child that she bore and brought into this world was conceived, all life is precious. From the life of the child that's conceived through a brutal crime that we punish with up to life imprisonment in this state, to the child in the neonatal intensive care unit, to the children we cherish in our communities, we recognize the preciousness of human life. And what HB 481 does is seeks to recognize that the child in the womb that is living distinct from their mother has a right of life that's worthy of protection. I think we should all be able to agree on that. That shouldn't be a partisan issue, that a child in the womb should be worthy of full legal protection. The challenge we face with the bill HB 481 seeks to address is how we balance this very tenuous and difficult question, Mr. Speaker, of the privacy interest of the mother with the life interest of the child. HB 481 was created not in ways that other states have addressed this. There are people that say, oh, this state or that state's done a heartbeat bill. This isn't a heartbeat bill, friends. This bill is created to recognize and reconcile the life interest of the child and the privacy interest of the mother that's recognized in our courts.
Gentlemen will suspend. I'm going to ask the clerk to read House Rule 1.1.
All members and staff of the House shall conduct themselves in all time with dignity and with respect for others in a manner to ensure appropriate decorum in the deliberations of the House and to reflect the responsibilities incumbent upon a member or staff of the House.
This is a very serious debate. The chair is going to ask that everyone conduct themselves with the dignity that's required by this rule and with respect for every other member in this body. Well, I guess we have some people in violation of the rules of the House. Gentlemen, will proceed, and this will be dealt with.
Thank you, Mr. Speaker. And I just want to say that I deeply respect the opinions of those that have been heard. I think this is a delicate issue that we want to address appropriately. Mr. Speaker, members of this body, the Living Infants Fairness and Equality Act was drafted as a unique recognition of the humanity of the child in the womb. It's created and addresses head-on the issue to reconcile the privacy interest of the mother that's been recognized in our courts, and we all know has moral validity, with the humanity of the child. How we reconcile those two things, that's what this is about. This is not a political document. It's not a statement. It's a reconciliation of this very, very difficult and even timeless question of the privacy interest of the mother and the life of the child. What the Living Infants Fairness and Equality Act seeks to do, Mr. Speaker, as we walk through the legislative findings, is lay out the legal case that we as a state are rightly acting on, and I think this body will rightly act on tonight, recognizing that dating back to 1868, when the 14th Amendment of the United States Constitution was crafted, it was crafted to do one thing. It did a number of things, but its central purpose was to recognize particular classes of persons that had not been previously recognized as having rights. There are entire classes of people before the 14th Amendment that had never been recognized as having equal rights, and it expanded it to new classes of persons. In that tradition, and consistent with our state constitution, this bill, HB 481, makes that recognition. It recognizes that in the womb, children are living, they're distinct from their mothers, they have their own blood types, their own DNA, their own characteristics that are immutably theirs. Mr. Speaker, it also recognizes that in the 1980 California United States Supreme Court case, Pruneyard v. Robbins, 1980, that states may recognize fundamental rights more expansively than the minimum standard required in state law. This is important, friends, because I want us to understand the legal framework we're operating under and the wisdom that underlies the wisdom of HB 481. In the Pruneyard v. Robbins case, there's a recognition that if states more expansively recognize rights, it's not in conflict with our federal Constitution as long as it's above the minimum standards the U.S. Constitution recognizes. We recognize this currently under our Georgia Constitution. Our Fourth Amendment rights against unreasonable search and seizure are more expansive here as Georgians than the federal law requires. We also recognize that in Massachusetts, the state of Massachusetts recognized same-sex marriage before the federal law required them to do so. The Constitution said you want to recognize the franchise of marriage more expansively than the states require. Massachusetts may do that. And following that same legal tradition, we're recognizing the rights of the child in the womb more expansively than the minimum standard that federal law requires. Mr. Speaker, as we walk through this, and again, I don't want this message to be about distractions. This is a very important issue. As we walk through this, we recognize that it's our job as legislators to legally recognize and to provide a legal framework that's anchored both in our federal Constitution and in our state Constitution, and that's exactly what this bill does. This bill, Mr. Speaker, also recognizes that in the Planned Parenthood v. Casey decision that the point of viability is the standard by which the courts measure legislatures' ability to restrict abortion and that the point of viability, the heartbeat, medically, that is the standard by which the American College of Obstetrics and Gynecology recognizes a viable pregnancy. And it's also the time we recognize that under our laws dating back almost 40 years, that when there's a human heartbeat, when there's respiratory activity, and friends, when there's brain activity, if any one of those three exists, a person's not dead. We recognize that throughout all life. If a coroner comes to look at somebody who's been in a terrible car accident, if they have a beating heart without life support, they're alive. So medically, we see the heartbeat's the standard. We see it in all other forms of life. The heartbeat is the standard by which the viability of the person is deemed alive. We follow, and as we follow the court's direction, the point of fetal heartbeat is that place that defines where the privacy interest of the mother meets the life interest of the child, and we can certainly agree that heartbeat is sort of the middle ground we can meet to recognize that. Friends, I know with the distractions out there, and I know there are some that have intentionally distracted this body. I don't want to go on. There's so much more I'd like to walk through, but I will walk through the specifics of the bill. Mr. Speaker, if I could have people turn the page to section 2.1 of the bill. There's a recognition that as we recognize the life of the child, there are certain statewide head counts and census counts that would be appropriate for us to count them. It does that here. It doesn't affect the U.S. Census, but for state purposes where it's appropriate, this bill allows that to happen. As we work through section 3.1 of the bill, there's a recognition that the point of fetal heartbeat, this important, medically important threshold, this is the point where the privacy interest of the mother meets this life interest of the child. Let's agree that when there's a beating heart, medical science tells us that's the threshold for a viable pregnancy. That's the point at which this body would be wise to act in protecting human life. Mr. Chairman, there's, at the behest of others, even though we recognize that no matter the matter of conception, whether someone is conceived through rape or someone's conceived through a loving family, that the innocence and the value of the life is all the same. Many members have come to me in an effort to work in a bipartisan way, which is certainly my hope, in a way that can be adopted by many of our members. The difficulty of a circumstance in which a woman is raped, it's been asked of us to consider, and I offer in a way that, again, I hope will bring bipartisan support to this. If a woman's been raped in this bill in Section 3.1, there's a recognition of that. And up to 20 weeks, which is our current standard, a woman would be allowed to pursue an abortion if she's raped. Our current law at 20 weeks prohibits abortion with no exceptions. That doesn't change in this bill, but up to 20 weeks under this law, if a woman were raped, she could still pursue an abortion. But if that were not the case, we recognize the value of that life, the distinct, living, whole human being that's inside that mother. This bill recognizes, and I think we as a body are wise to recognize as well. Mr. Speaker, I will conclude by saying that, again, to recognize the cost and the significance of a human being coming into this world. We recognize parents who are parents who are pregnant with their first child take on extra medical costs. They, in many cases, the mothers have to spend time on bed rest or out of work. And what this does is it gives a simple recognition that if the parents are pregnant with a child, that child would qualify for a state tax exemption. Very simple act, but it is something that's a recognition of the child in a very practical way that affirms life, that takes care of these families, and brings us to a common sense place that reconciles this very difficult question of the privacy interest of the mother and the life interest of the child. And how we balance that says a lot about who we are as a state. I know everybody in this chamber recognizes the preciousness of life in the womb, and this is an opportunity for us to affirm that today. On that, Mr. Chamber, I know Mr. Speaker, there's other folks in this chamber who want to speak on this bill. I would urge your support for HB 481. Yield the well.
Gentleman has yielded the well. There are members who wish to speak to the bill. 30 minutes per each side. Chair recognizes Governor's Floor Leader, Representative Lott, to speak to the bill.
Thank you, Mr. Speaker. I rise today in support of HB 481, the Living Infants Fairness and Equality Act, the Life Act. Life is precious. All life is precious. And I must speak up for this bill so that we can stop the death of thousands of innocent lives in our state. Georgia values life. We must stand up for those that cannot speak for themselves. There are a coalition of states also supporting the life of the unborn, and together we hope to restore the authority of the states to determine this important issue. We will continue the conversation. We will improve foster care. We will improve adoption options and opportunities in the state of Georgia. We will continue to talk about health and wellness of mom and baby. Our governor is committed to putting Georgia families first and recognizing the precious nature of all life, and I proudly join him in this fight for life. Thank you, Mr. Speaker. I yield the well.
Chair recognizes Chairman Darlene Taylor to speak to the bill.
Mr. Speaker, members of the House, good evening. I rise to speak about House Bill 481. I appreciate this opportunity to share my thoughts. What a great state and country we live in. All have had their say. Look at all the folks that have spoken and that will speak. Our freedom of speech is valued above all. We can demand to have our say, and we do. We have just witnessed that today. We've seen it all day long. People have been speaking and saying what's on their mind and heart. Even if it's inaccurate or unpleasant, you had that right to say it. But who speaks for the baby named fetus? Who speaks for the baby named fetus? Well, today I'm going to. To quote baby fetus, I deserve to have the right to. Some may squirm in their seats or turn their backs, but I will speak today. Baby fetus says, and I quote, I have that right. Don't be afraid or intimidated about acknowledging me. You know in your heart, I am life. If a pregnant woman is murdered, it's a double murder. My life counts. If you don't want me, someone does. We are a nation hungry for babies to adopt. Someone wants me. What kind of a nation throws away life? Baby fetus has value, and whether you realize it or not, it's value to you. God only knows what is missing in our lives from the generations of abortion. By the way, half of those were future women. Baby fetus deserves to have a future and to have a life. Baby fetus deserves to have a life. Thank you, Mr. Speaker. Baby fetus and I yield the well.
Chair recognizes Chairman Fleming to speak to the bill.
Thank you, Mr. Speaker. When I was a young lawyer, I used to drive downtown Augusta to my office every day, and I used to have to pass Planned Parenthood, where they do abortions. And quite often there would be some protests out there, people on the sidewalk. One day I drove by, it was a cold day, probably February, and there was one elderly lady out on the corner with a protest sign. And there were two very large police officers standing over her, and it just didn't look right to me. So I pulled in a parking lot across the street, and I watched for a second. And I got out of my car, and I walked over to this elderly lady, and I said, ma'am, I don't know you, and I don't know what you're doing here in front of Planned Parenthood except protesting, which you have a right to do. And I said, I'm a lawyer, and I understand that. And it just didn't seem right how these people were acting towards you, these two police officers. About that time, the two police officers walked back from their squad car where they were, and she immediately introduced them. She said, gentlemen, this is my lawyer. I'd like for you to meet him. I didn't know the lady's name, but I had a conversation with the police officers, and I let them know that she had a right to be there. After they walked back to their squad car, apparently she'd stepped off the sidewalk, and they'd gotten on to her about it because the Planned Parenthood people had called the cops on her. After the cops went back to their squad car, I struck up a conversation with them. I said, ma'am, it's kind of cold out here. Are you okay? She said, when my daughter was a freshman at Clemson University, she got pregnant. And she didn't come to me or her father then. She came right here to this Planned Parenthood, and she aborted the child. She said about 6 months after that, my daughter was having a terrible time. She put a gun to her head, and she pulled the trigger. She said, but she didn't kill herself. She said, I have been changing her diapers for 25 years. It's not just what it does to the babies that are killed. It's also what it does to the lives that are left behind and the scars. It's not just the scars that it puts on the women who go through it and the other loved ones in their life who have to live through it with them and the after effects. It's the scars that it leaves on our society. When you can take an innocent life, you devalue all life. And our nation and our world has suffered for it ever since. Vote in favor of this bill. Decrease the scars that are left on our society in Georgia. Mr. Speaker, I yield the well.
Chair recognizes Representative Gertler to speak to the bill.
Thank you, Mr. Speaker. I rise in support of House Bill 481. Earlier this year, millions of Americans came together all across America to march for life, for the innocent and for those human beings uniquely and wonderfully made in God's image. Earlier this year, we also had and watched several states use the power of government to further legitimize infanticide. The Virginia House introduced a Repeal Act, which would allow a healthy baby to be killed up to the moment of childbirth, even while the woman was dilating. The governor of Virginia, Ralph Northam, doubled down and said in an interview that the baby would be born, made comfortable, and then doctors and mothers would decide whether or not that baby should live or we could let it die. A living, innocent human being. Now that is murder. Ending life after birth, simply for not being wanted. For all the talk of how progressive we have become and how we live in a civilized nation, how barbaric have we become to now openly be talking about killing life after birth? I became physically sick just thinking about that scenario. New York Governor Cuomo also signed legislation allowing the killing of unborn children at the moment of birth. In fact, a man accused of killing a pregnant woman in New York will now only be charged with a single homicide, thanks to the Governor Cuomo stripping the rights of that unborn child. Now, what are we going to do, Georgia? I was taught that life is a gift from God, that is precious, and that life is about being responsible for oneself and to help those around us. The golden rule. The Bible teaches us that. And even though those may not believe in God may be here, we can acknowledge that life, that the value of treating others, and the one we treated ourselves. What are we going to do? Now, we have a moral obligation as decent human beings to stand up and protect the most vulnerable in our society. Protecting and defending life, liberty, and property is the proper role of government, and that's why we're here. What will history say about us as a people if we do not stand up and if we do nothing to protect our fellow man? I contend that we will be judged in how we treat those that are the weakest among us. Some worry we have killed some 60 million since Roe versus Wade. Abortion was pushed and advocated under the guise of safe, legal, and rare. Now we have sitting governors saying it's okay to actually just kill that baby after birth. We have devalued life and created a death culture. The time to act is now. No more excuses. We have the majority in the House, the Senate, and the executive. We all campaigned on this to protect life. We have controlled Georgia for nearly 20 years. There is only good and evil in this world. There's only right and wrong. We must speak up and do what's right or suffer the consequences. As Dietrich Bonhoeffer said, to not act is to act, and to not speak is to speak. I ask my colleagues to stand up for what is right, to support House Bill 481. This bill is simple, it protects life, and it's something we all took an oath to do in our Constitution. Thank you, Mr. Speaker. I yield the well.
Chair recognizes Representative Walensky to speak to the bill.
Thank you, Speaker. Make a couple quick points. Under this bill, it gives broad overreach to the term of the embryo of life. So that means if after the baby has a heartbeat, that if a pregnant woman is walking through the street, jaywalking, and she trips and falls, and that embryo goes away, that would be manslaughter. Under this, the definition of what we're doing, we're giving that embryo full rights. That would be manslaughter if a woman just trips and falls while jaywalking because she was committing a crime. Once again, it gives full rights of a person. So that means that if a woman is 8 weeks pregnant and somebody rear ends them, and that 8-week child, or excuse me, that 8-week embryo, something happens to it, the 8-week embryo, that means that the person who caused the collision would have a wrongful death claim against them. The record for a baby surviving outside of the womb is 18 weeks. Medical testimony says that before 21 weeks, an embryo has a 0% chance of living. And last thing about this is that we know that this bill is unconstitutional. We know that there's going to be huge costs to litigate this. So we're about to pass a bill that will cost the state a ton of money, and also that it gives a baby or the family to make a tax exemption, which is more money to the state, and we have no fiscal note. So I ask that we vote no against this bill because it's unconstitutional.
Chair recognizes Representative Jasmine Clark to speak to the bill.
Thank you, Mr. Speaker. I come to you today to ask you to vote no on this bill, but I'm going to come at it from a very different angle. I would like for everyone to draw your attention to lines 78 through 84. On those lines, it mentions the American Academy of Obstetrics and Gynecology. Now, you can take my word for it, or you can Google it yourself. That organization does not exist. What I think the author of this bill meant to quote is the American College of Obstetrics and Gynecology. Well, if you look on your desk, a statement from the American College of Obstetrics and Gynecology says that induced abortion is an essential component of women's health care. And further down, they define fetal viability as the capacity of the fetus for sustained survival outside of the woman's uterus. If we are going to use the definition from an organization to define viability, then let's use the definition from that organization to define viability. Thank you, Mr. Speaker. I yield the will.
Chair recognizes Representative Scott to speak to the bill.
Thank you, Mr. Speaker. It isn't up to the government or this body to tell me or any woman to give birth or not. And this is what denying access to abortion amounts to. Banning abortion does not eliminate abortion. It just makes it less safe and puts pregnant women and their families at risk. Thousands of women lost their lives to unsafe abortions before Roe. Since the legalization of abortion, it has become one of the safest medical practices in the United States. Before Roe, in states that banned the procedure, women were receiving illegal, often unsafe abortions that could put their health, lives, and families in jeopardy. Women are more likely to stay in abusive relationships when they are unable to access abortions. Mr. Speaker, I yield the will.
Chair recognizes Representative Holland to speak to the bill.
Thank you, Mr. Speaker. I'm here tonight to ask this body to vote no on this measure. At its heart, this bill eliminates a woman's ability to make health care decisions with her doctor. What does that mean for us in the state of Georgia? Well, in a state that already has a shortage of OBGYNs, where half of the counties in Georgia do not have a practicing OBGYN, in a state that has the worst maternal mortality rate, not just in the country, but in the developed world, we would make it harder to recruit doctors to treat women here because this bill eliminates a woman's ability to make health care decisions with her doctor. When a young woman with type 1 diabetes discovers that her contraception has failed, she cannot do anything to further treat her diabetes because this bill eliminates a woman's ability to make health care decisions with her doctor. When a mom of 2 discovers that she's pregnant after a breast cancer diagnosis and will have to forego life-saving chemo treatment, that's because this bill eliminates a woman's ability to make a health care decision with her doctor. When a woman in an abusive relationship discovers she's pregnant and no longer feels she has the resources to leave her abuser, it will be because this bill eliminates a woman's ability to make a health care decision with her doctor. Or when a college student with a heart valve abnormality experiences sexual assault and is too afraid to file a police report, she will no longer be able to treat that valve abnormality because we have eliminated her ability to make health care decisions with her doctor. This bill would be devastating to our state's ability to look after our women and care for our most vulnerable citizens. I ask that you vote no on this bill. Thank you. I yield the well.
Chair recognizes Representative Anulowicz to speak to the bill.
Thank you, sir. I rise tonight to speak against House Bill 481. Not only is it unconstitutional, it is a bill that has neither compassion nor medical integrity. I have been pregnant twice. Each pregnancy resulted in a healthy outcome. I had a lot of heartburn. I do not recommend hours and hours of unmedicated Pitocin labor. But with both pregnancies, my husband and I left the hospital with a healthy, gorgeous, thriving baby. As we've discussed, the unfortunate reality is that not all pregnancies have the same outcome. Too often, the discovery of an anomaly leaves parents with a heartbreaking decision. There are several examples of congenital anomalies that are incompatible with life. Anencephaly. This is when a baby in the womb has the absence of the brain, the skull, the scalp. There are profound chromosomal abnormalities like trisomy 13, trisomy 18. There's fetal hydrops, where excessive accumulation of fluid prohibits the organs from properly developing in a fetus. For most pregnancies, these anomalies are discovered around 20 to 22 weeks gestation, with typical scans, things that happen. The wait is even longer because you have to wait sometimes for further tests to get more conclusive results for what is going on with the baby. If a woman has had previous issues with fetal anomalies, she might be able to have a blood test to look for anomalies. The earliest this test can take place is around 10 to 12 weeks. A fetus with these medical conditions will have a heartbeat. The human body is an incredible thing. The uterus is an amazing vessel. But a heartbeat does not mean that a baby with one of these conditions can live for even a moment outside of the womb. Any child born with these conditions, if they survive birth, will require intense medical interventions and life support to survive for even a few days. If women are forced to carry these pregnancies to term and forced to deliver, these children will suffer. These women will suffer. This is what House Bill 481 means for families in Georgia. For women, for parents, the ability to make the decision of how or whether to proceed with such a pregnancy is of critical importance. We must protect a woman's right to make this choice. And I'm going to be quoting my predecessor, Representative Stacey Evans, when she was up here on the video screens several years ago when she was en route to deliver her first child. This is a choice that can only be made between a woman, her partner, her doctor, and her God. I yield the well.
Chair recognizes Representative Wynn to speak to the bill.
Thank you, Mr. Speaker. Yesterday in committee, the sponsor of this bill said, they came to me, and when they asked to provide an exception that a child conceived of rape or incest, that an abortion wouldn't be prohibited, starting at human heartbeat, I have misgivings about that in many ways, because I believe those children are just as innocent as others that are conceived intentionally. As a matter of members coming to and saying, let's get a consensus bill so that we can get bipartisan support, perhaps in the chamber, I added lines 164 to 166 because some people believe that rape is an important exception to have in this Part B. To the author of this bill, adding an exception for survivors of rape and incest in no way makes this a bipartisan bill, and there are members of your own party who don't want to vote for this bill. To the author of this bill, I too have many misgivings about requiring victims of rape and incest who are just as innocent as others to file a police report. A Georgia man repeatedly raped his daughter, and this resulted in the birth of 8 children. She gave birth to her first child at age 17. I ask you, at what point does this 17-year-old have the ability to file a police report against her father and her rapist? For the last 10 years, I've worked with young women in Georgia public high schools. I know their horrific testimonies of rape and abuse. These crimes remain unreported because the abuser is a family member in their very own household. When we talk about human life and protecting innocent children, why are we not talking about protecting the lives of women and girls? Who protects these victims of rape and incest? Requiring rape and incest victims to file police reports to obtain an exception to the 6-week rule is cruel, and it opens the door to many questions. Is a police report enough to obtain an exception, or will the exception require a conviction? Is the author of the bill worried that desperate women and girls will use the exception to file false reports because they feel they have no other choice? And how do we protect victims of rape and incest who are afraid to file a police report against the perpetrator because fear of retaliation? And why should any woman or girl have to file a police report in order to obtain an abortion? The answer is we don't, because under federal law, we as women have the constitutional right to make decisions that are best for our lives and the lives of our families. This will be struck down in the court of law, and when Georgians go to the poll, we are going to remember that members in this body chose to ignore the 71% of people who want access to safe and legal abortions. I yield the well.
Chair recognizes Representative Moore to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, I rise with sadness today that the devil is at work in this chamber. His mission is to sow fear, lies, and discord among us, and to test the bonds of our friendship. Though my God calls upon me to forgive those who would trespass against me, now is the time for men and women of conscience to rise up to reject this awful bill. Proponents of this bill claim to have scientifically identified the point at which our spiritual souls intertwine with our physical bodies, arbitrarily defined as our circulatory system. To define our infinite existence to a single physical attribute is to reduce God himself. For I believe that our souls, the very essence of who we are as children of God, exist long before the embryo and continue long after our mortal hearts stop beating. This bill seeks to replace the good grace of God with the strong arm of the government, sending a message to the people of Georgia that they need not seek a relationship with the divine, because the government is now the moral arbiter of our lives. The moment we relinquish reproductive rights from the individual to the government, it is only a matter of time before that same government that bans abortions will begin requiring them. A curious statement was made yesterday in the committee hearing. It was said that no one loves abortion more than pimps and human traffickers. Assume for a moment that statement is true. Why would they love it? Because pimps and human traffickers love controlling women's bodies, which is exactly what this bill does. This bill does not distinguish us from them. It makes us exactly like them. You know who else loves to control women's bodies? The most autocratic, theocratic, undemocratic nations in the world. Places like Saudi Arabia, North Korea, Afghanistan, places where our brave men and women in uniform are fighting to liberate people from loathsome policies like this bill. I leave you with this simple notion, colleagues. God was intentional when he gave women the power and the privilege of childbearing, not men, not governments. If you trust God, then you must trust women, and you must vote no on HB 481. Mr. Speaker, I yield the well.
Chair recognizes Representative Paris to speak to the bill.
Thank you, Mr. Speaker. Colleagues, I rise before you today in strong opposition to House Bill 481, commonly referred to as the Life Act. I am concerned about this heartbeat bill because it challenges the already fragile state of women's health here in Georgia. Health care is already lacking, with 79 counties having no OB/GYN, 64 counties having no pediatrician, and 9 counties having no doctors at all. Rural hospitals, labor and delivery facilities are closing more often than not. And many of our neighbors are forced to seek alternative methods to get the treatment and care they desire and need. This is unacceptable, and this bill will only make that lack of access to health care worse. May I remind my colleagues in this chamber that Georgia is not only the #1 state to do business, but unfortunately, we are also the #1 state where mothers die, as we have the highest maternal mortality rate in the nation. To make matters worse, the trauma and depression that women who do live will experience due to carrying a non-viable fetus to term. The ability to make decisions regarding medical care should never be decided in the halls of this Capitol. This is a human right reserved for the mother, her family, her physician, and most of all, her God. I would rather my constituents listen to the advice of their doctors, not a legislator. We had expert advice yesterday, and it was all just thrown out the window for the sake of what powerful people in position feel like is their decision to make. How we got to this place where facts no longer matter, I do not know. But I think that it is incumbent upon us to get back to the facts. In closing, this bill has no fiscal note attached, seeing how not a single state in this country has managed to put similar legislation into lasting practice, as courts have continuously deemed them unconstitutional. I would like to see how much it will cost taxpayers to even defend this in court if this assembly does pass this legislation. I truly believe that Georgia is better than this. Our neighbors deserve better than this. Let us do the right thing and vote in opposition of House Bill 481. Thank you, and I yield the will, Mr. Speaker.
Chair recognizes Representative Erica Thomas to speak to the bill.
Thank you, Mr. Speaker. No one is more appreciative of life at this point than I am. In August, I will have the privilege to bring a beautiful life to this earth. But that decision was my husband and I's decision to make. And no one in this chamber had the right to make that choice for me and my family. And no one in this chamber has the right to make that choice for any woman in Georgia. One of my great friends had a mother that had stage 4 cancer. She had to choose between chemo and having her 11th child. I wish that I could look up in this stand today and recognize her, but I can't, because she made a choice to have her child. And for her, that was an amazing choice. Yes, she left behind 11 children, but she made the choice that she wanted to make. And today I stand before you to tell you that no one had the right to make that choice for that family. So when you vote on this bill, I want you to see how powerful it is for a woman that is 5 months pregnant to stand up here and say that, yes, I chose life, but I will not choose for anyone else. I yield the will.
Chair recognizes Representative Lopez Romero to speak to the bill.
Thank you, Mr. Speaker. I rise today to stand with the women and their right to their own reproductive health. For the women, the 4 Latinas that I know in my life that have made the choice to terminate their pregnancy for various reasons. One that was seeking to be pregnant, but their child would not be viable at birth, and made a very heart-wrenching decision to have to terminate her pregnancy. Another that was assaulted, but could not bear to tell and did not have access to a safe and legal abortion and took things into her own hands. Another who had already 3 children and knew her body and felt she could not carry another child. Another that it was not a point in her life that was that it was something that she could continue with. But I also stand today for the reproductive choices that women make when they also choose to carry their pregnancy to term, regardless of the circumstances, whether it be a healthy, problem-free pregnancy or whether it may in fact have complications. I rise for that choice to determine the course of women's own body. Thank you, Mr. Speaker.
Chair
yield the will.
Chair recognizes Representative Silcox to speak to the bill.
Thank you, Mr. Speaker. I come to y'all tonight, first of all, as a Christian. Jesus saved me from cancer when I was 16 years old, and I was given a 20% chance of surviving. And by the grace of God, I was able to have 2 children. And I value those children so much, and I value life so much. My parents were told that I would never have those children because of all the chemo and radiation that I had. But I have heard from thousands of people in this state and in my district, thousands of women. And I have heard from obstetricians who practice in this state and genuinely do not want to be criminalized for caring for women in our state for what they do. And so I rise to vote against this bill. And I rise for my constituents and for those people because I was sent here by them to vote for them. I just pray, Lord, that your will be done. And I pray, Father, for the great state of Georgia. I yield the well.
Chair recognizes Representative Dreyer to speak to the bill.
Thank you, Mr. Speaker. I rise in opposition. We should not be making this decision, but at a minimum, if we are going to be making this decision, it should be women in Georgia that are making this decision, not a body comprised primarily of men. I am speaking because women in my leadership have asked me to speak. And so I stand in solidarity, and I stand as an ally to women in Georgia. And I will vote no in solidarity with women and on behalf of my constituents. But I am never going to tell women what to do with their bodies, so I will be voting no. Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. We have a minority report. By rule, the minority report is limited to 20 minutes. Chair recognizes Chairman Beverly for the minority report.
Thank you, Mr. Speaker. This is probably one of the most heavy bills we'll deal with this year, and so I yield 10 minutes of my time to Representative Park Cannon, and the remainder of the time to Representative Renita Shannon. Representative Park Cannon.
Chair recognizes Representative Cannon.
Thank you, Mr. Speaker. My name is Park Cannon, and I am proud to represent the district that includes Grady Hospital, where many of the women affected by this legislation will turn up, and the surrounding streets of this state capital. I am disheartened that this body is spending the last moment of the last day deliberating what will be determined an unconstitutional measure. I stand here today confident in my decision to terminate my pregnancy when I was sexually assaulted in 2010. As a member of the LGBTQ community, there are many people who believe they can, quote unquote, rape us straight. I do not deserve to live in a world or a state where people believe that I should be shamed because of my sexual orientation. Many of you know that I now work to help women and families contemplating this decision in English, Spanish, and Portuguese. Today I bring to you our minority report on House Bill 481. We have given amendments on this bill that we shared even in Rules Committee today. We have talked about how including fetuses of 6 weeks in the state-based populations is impossible, as the bill calls. We know that women make up 52% of our state population. So even if half of those women are pregnant, there is a major new set of numbers that we need to know for state-based calculations, and that deserves a fiscal note. But there is no way for us to do this. It is a flawed idea. It begs that women who are pregnant can ride in the HOV lane. It also asks how we claim for the full value of the life of the child. Do we use life insurance to do that? Additionally, this bill opens physician records to law enforcement. Standing in front of the law enforcement in the gallery are many members who have come here today to speak against this bill. I would like for them to stand to be recognized. I want to make it clear that the heartbeat is not an indication of viability. We need to trust doctors. Many of them are in this room today. In our minority report, it spells out a zygote. It spells out an embryo. It spells out the embryonic period and when that ends and when it becomes a fetus. We talk about a fertilized egg. You want science? We've given it to you. In the Health and Human Services Committee, we did not share our sob stories. We brought doctors to speak to the measure. Instead, 17 members voted in support. I would like to pray for those representatives who are on the floor today. Representative Barr, Chokas, Dempsey, Gaines, Hatchett, Hawkins, Hope.
The lady is out of order.
I would like to return to the minority report that is on your desks. In us understanding the importance of this legislation, we need to look at this measure in totality. It is not scientific. It is not medical. It is, in fact, political. We have seen other political circumstances created. We need to ask for not only a fiscal note on this measure, but we also need to create a way to have a dialogue on viability. We need to create a space for doctors to feel safe in the state of Georgia. In the minority report, we have spelled out 79 counties in the state of Georgia do not have OBGYNs. We have spelled out that this will make doctors want to leave our state. We know how important it is to address our maternal mortality rates, and we would like to return to that matter. That will take fiscal notes. That will take study committees. We are looking forward to working on those, but by passing this legislation today, we will instead spend time fighting this in different courts in our state and outside of our state. I yield the rest of my time to Representative Renita Shannon.
Chair recognizes Representative Shannon for the balance of the chairman's time, or the minority report.
As we approach the prospect of a Supreme Court including 5 justices who will vote to overturn Roe v. Wade, it is essential that we not forget the world as it existed before 1973. So let me bring you just a bit of that reality back to life. In the years leading up to Roe, more than 1 million women each year face the crisis of an unwanted and unplanned pregnancy, found it necessary to resort to illegal abortions. The vast majority of these women turned either to dangerous self-induced abortions or to the dark and often forbidding underworld of back alley abortions. Women who resorted to self-induced abortions typically relied on such methods as throwing themselves down a flight of stairs, or ingesting, douching with, or inserting into themselves a chilling variety of chemicals. and toxins ranging from bleach to turpentine to gunpowder to whiskey. Knitting needles, crochet hooks, scissors, and coat hangers were among the tools commonly used by women who attempted to self-abort. Approximately 30% of all illegal abortions in the 1960s were self-induced. Women who sought abortions from back alley abortionists encountered similar horrors. To find someone to perform an illegal abortion, women often had to rely on tips from elevator operators, taxicab drivers, salesmen, and the like. Because of the clandestine nature of illegal abortions, the very process of finding someone to perform an abortion was often dangerous and terrifying. Women who sought back alley abortions were often blindfolded, driven to remote areas, and passed off to people they did not know and could not even see during the entire process. Such abortions were performed not only in secret offices and in cars, literally in back alleys. The vast majority of these abortions were performed either by persons with only limited medical training, such as physiotherapists and chiropractors, or by rank amateurs, including elevator operators, prostitutes, barbers, and unskilled laborers. In the 1960s, an average of more than 200 women died each year as a result of botched illegal abortions. The mortality rate for Black and Hispanic women was 12 times higher than the mortality rate for white women. In addition to those who died in the course of illegal abortions, many thousands more suffered serious illness or permanent injury. Because of the humiliation associated with having an illegal abortion, many women who suffered complications were reluctant to visit a doctor for treatment. The stories of women who suffered through this nightmare are legend. One woman recalled how a fellow college student who had an illegal abortion was too frightened to tell anyone that she had done so. She locked herself in the bathroom in her dorm and quietly bled to death. In another incident, a 28-year-old Geraldine Santoro bled to death on the floor of a Connecticut hotel room after she and her former lover attempted an abortion on their own. The former lover, who had no medical experience, used a textbook and some borrowed tools. When things went terribly wrong, he fled the scene, and Santoro died alone. This was the reality of life for 1 million women each year in the world before Roe v. Wade. Is this the world that we wish to return? What I have just read to you is a history of what life was like for women before abortion was legal. So let's be clear, no matter what kind of law you pass to outlaw abortions, women will continue to seek and have abortions. They will just seek risky measures to have them, measures that could easily result in their deaths. Any bill that outlaws or restricts a woman's right to choose, right to access abortion care, is a bill that is calling for the policies of forced birthing for women. Similar to what you see on the popular show, The Handmaid's Tale. The women of Georgia can clearly see what this bill is about. They know it's forced birthing, and they know that they don't pay taxes to send their legislators down here to legislate their reproductive rights away. So let's get down to the root of what anti-abortion bills are about, and that is that government, which is still mostly male, does not trust women to make decisions about their own bodies. The women of Georgia are fully capable of making their own decisions, and we do not need your condescending bills that challenge our bodily autonomy. I had an abortion almost 20 years ago when I was a senior at the University of Florida. Now, my pregnancy was not the result of rape or incest, but abortion was the right decision for me. I do not regret my decision. I didn't regret it at the time, and almost 20 years later today, I do not regret my decision. And I am not scarred. I still do not regret my decision. It is time for government to simply do one thing: trust women. We might disagree on whether or not women should have the right to an abortion, but you cannot dispute the results of what has happened when governments have banned or restricted abortions. Now I'm going to talk to you about the consequences of El Salvador's abortion ban. And the reason I want to talk to you about this is because it's very similar to what would happen in Georgia if abortion was banned. In 1998, El Salvador passed a law banning abortion under all circumstances. Until that point, abortion was illegal except in cases involving risk to maternal life, severe fetal anomaly, and rape or incest. Since then, El Salvador has worked to enforce its ban, mounting an intensive effort to identify and prosecute those who violate the law. If we're hoping to understand what happens when abortion is banned, El Salvador is the perfect place to study. Regardless of whether one favors or opposes the abortion ban, it is vital that we assess the law's impact. A law cannot be justified merely because one likes its message. Even if you like the message of the law, it is valid only to the extent that it produces results that are consistent with its message. So what happened when abortion was outlawed in El Salvador? The evidence shows us that 3 things occurred. Number 1, abortions remained commonplace and rates did not drop even though it was illegal. Doctors became involved in law enforcement. And number 3, innocent women were accused and convicted of abortion-related crimes. These 3 systems, the black market, healthcare, and criminal justice, all yield measurable consequences of the ban on abortion. And as I explained below, in spite of the vast differences between El Salvador and the United States, there is good reason to expect that the United States would experience each of these 3 consequences were it to outlaw abortion. Abortions still happen. Perhaps the most surprising thing about banning abortion is what doesn't happen when abortion becomes a crime. Abortion does not go away. Indeed, the rates of abortion in countries with the most restrictive abortion laws are higher. This is true in El Salvador. By the Salvadorian government's own measure, there are tens of thousands of illegal abortions every year. Indeed, the rate of abortion in countries with restrictive abortion laws far exceeds that of countries with far more liberal laws, such as the United States. There is one thing we know for certain. Abortion doesn't simply go away when it is made illegal. Because abortions are illegal, it is hard to get a complete picture of how women obtain them in El Salvador. What is clear beyond a doubt is that the advent of abortion drugs has completely altered illegal abortion. Abortions used to be exclusively surgical procedures. Doctors would terminate pregnancies by opening the cervix and suctioning or scraping out the contents of the uterus. Women unable to find or afford a doctor to perform an illegal abortion might try bringing on a miscarriage themselves. For example, by inserting a sharp object into their uterus. Opening the cervix is enough to induce a miscarriage, although it carries with it high risk of excessive bleeding and infection. Historically, these so-called botched abortions provided the only proof of crime in illegal abortion. Coat hanger abortions, for example, were notorious in pre-Roe America, in part because they carried a high risk of perforating a woman's uterus, leaving behind the telltale sign that the woman had deliberately ended her pregnancy. Beginning in the 1990s with the advent of abortion drugs, illegal abortion became safer and harder to detect. Taken in the appropriate dose at the right point in pregnancy, the drug known as RU-486 will safely end 98% of pregnancies. Side effects include excessive bleeding or incomplete abortion, but readily resolved by a visit to a doctor. Although they are not always safe or effective, especially when taken too late in pregnancy or at the wrong dose, compared with the risk of illegal surgical abortion drugs, RU-486 have completely altered women's access to illegal abortion. In El Salvador and throughout Latin America, women find easy access to illegal abortion drugs via the internet. In Brazil, for example, when abortion is illegal except in cases of rape, threat to maternal life, or where the fetus lacks a brain, abortion drugs play a vital role in the thriving black market. An estimated 1 in 5 Brazilian women under the age of 40 has had an abortion. Even in a poor country like El Salvador, almost everyone has a smartphone, and provided that they have money and time, can go online to purchase the drugs that will end an unwanted pregnancy. To be sure, illegal abortion remains risky, whether they use drugs or other means to terminate their pregnancies. Many women experience complications from illegal abortion that necessitate medical attention. In Latin America, complications from illegal abortion constitute the leading cause of mortality in young women. The inevitability of such complications has led to the second concrete change set in motion by banning abortions. Doctors become entangled in the law enforcement process. If the first thing that happened when El Salvador banned abortion was the proliferation of illegal black market abortions, the second thing that happened was doctors were enlisted in the law enforcement effort. The overwhelming majority of abortion cases in El Salvador began in the hospital with a doctor's hunch that his or her patient had broken the law. In 1998, Salvadorian government officials charged with implementing the newly passed abortion ban reached out to doctors to encourage them to report patients they suspected of terminating their pregnancies. Dr. Guidos, former president of the El Salvadorian Association of Obstetricians and Gynecologists, described the state's approach. He told me, officials from the state prosecutor's office went to the hospitals, advising doctors that they had a legal obligation to report women suspected of terminating their pregnancies. And the hospital directors supported the obligation to report. They collaborated. The push to enlist doctors in enforcing the abortion law succeeded. A 2006 survey of practicing obstetricians found that more than half, 56% of respondents, reported having been involved in notifying legal authorities about a suspected unlawful abortion. Inevitably, a country seeking to enforce laws against abortion will seek doctors' collaboration. Women must turn to doctors when an illegal abortion goes wrong. Doctors are therefore in the best position to spot the crime.
1 minute left.
But there are serious problems with using doctors to enforce abortion laws. In reporting their patients, doctors break the law and violate the oldest of ethical principles, patient confidentiality. Furthermore, in the vast majority of cases, doctors cannot tell whether a woman has had an abortion or simply a miscarriage. Thus, their reports are based on hunches rather than on medical advice. The obligation of safeguarding a patient's secrets is ancient. For over 2,400 years, medical doctors have embraced the precepts articulated in the Hippocratic Oath, recited at medical school graduations worldwide. One of the oath's central tenets is the following pledge: whatever I see or hear in the lives of my patients, whether in connection with my professional practice or not, which ought not to be spoken of outside, I will keep secret, as considering all things should be private. The principle is based in part on policy considerations. Confidentiality is essential to creating a solid doctor-patient relationship, dedicated to promoting the health and life of the patient. Doctors routinely treat patients whom they suspect or even know to have broken the law. The medical profession has long been clear that its job is to heal rather than to work as agents of the police. In El Salvador, as in other countries, including the United States, the ethical obligation of confidentiality has been enacted into law. It is illegal to share patient information. A doctor who reveals her patient's medical information commits both a civil wrong, for which a patient might sue, and a crime, punishable by imprisonment and the suspension of the doctor's medical license. Regardless of these ethical and legal precepts, it is easy to understand why a doctor might struggle when encountering evidence of an illegal abortion. If you view abortion as the taking of a life, you might be willing to call the police, even if it means violating the norms and laws governing confidentiality. Salvadorian law supports such breaches of confidentiality, by requiring doctors to report suspected crimes to the state. Because abortion is a criminal act, this requirement could be construed to mean that providers must report cases of unlawful abortion to police. Plainly, this was the interpretation of the Salvadorian officials meant to convey when they toured hospitals in 1998. Legally, though, they were wrong. The law explicitly excuses doctors from this duty when the information is acquired in the course of a confidential doctor-patient relationship. The law states that doctors, pharmacists, nurses, and other health professionals must report
given a 1-minute
unlawful
warning,
criminal acts that they
and now
become
is 2
aware
minutes
of
over the
in the
time limit.
context of their professional relationship, unless the information they acquire is protected under the terms of professional secrecy. There is no conflict under the law, then. Doctors are required to maintain patient confidentiality. Still, when the state sends prosecutors to inform hospital personnel,
The lady will leave the well. The lady will leave the well. The lady would do well to heed the advice of her colleagues. We're going to We're going on now to the chairman's time, and in the absence of the chair, the Vice Chairman Newton will give the chairman's time, and he's recognized for that purpose 20 minutes by rule. 20 minutes.
Thank you, Mr. Speaker. Colleagues, what a passionate issue and what a challenge for all of us to be like Solomon in our decision making. 23andMe, Ancestry.com, many people in Georgia have learned of their relationships and their ancestry. They've done it with just a small sample. Small sample because we have the same DNA in every cell in our body, a genetically unique and a uniquely special individual since before each of us was born, each one of us in this room. We all know that others may likely and finally decide the degree of protection for unborn children. But today we have an opportunity to take a first step, a first small step in celebrating and valuing life at all stages. Foster children, for whom many in this body spent much of the last 2 years working to make a difference in their lives. Elderly fellow Georgians, for whom we're trying to advance protections even now. And yes, the life of a pregnant woman, along with the life of the unborn child in her womb. I did have the opportunity to meet several women today at the ropes, young women who were passionate on both sides of this issue. But if you will with me just a moment, imagine a young woman of 25 years old, a young woman who deserves our protection from those who would harm her. But she also deserved protection 15 years earlier. As a 10-year-old, a 5th grade student, a girl for whom this body has recently increased funding for school for school security, and will continue to do more. That same 10-year-old deserved protection 10 years earlier than that. As a newborn infant girl, protections this body has placed against those who would commit child abuse against a helpless, innocent infant girl. But she also, 6 months before that, with the exact same DNA in every cell, the same uniquely designed individual, and she deserved protection then. We know this in our minds because technology and science is giving us more and more information that was not there 30 years ago, much less 40 plus years ago. But we also know it in our hearts and our souls, and the joy that one of the fellow representatives mentioned about the life in her womb is touching, and she knows that life is valuable today. And I imagine she would fight to the death anyone that would try to harm that child either now or 6 months from now or 9 months from now or 15 years from now. And that is the right thing because we know it in our heart. This current bill doesn't ban abortion. It still allows a certain amount of abortion, so some are not happy with that. This bill would not ban a morning after pill or a Plan B if there was a rape or incest, with or with no police report required. But what this current bill would do is, for that young woman, prior to her birth, it would establish